Was this said that at that time?
It was not signed in nine. Of course.
No, was this
of course.
argument brought before?
Oh yes.
And
Oh yeah. No,
was
they thought.
disregarded.
No, they thought whatever we were saying was bonkun. That was the position of the government. I remember Professor Wole Soyinka, who is not a lawyer, was the first person to draw our attention to the legal monstrosity that was going on in The Hague. And we are dealing with human beings. Why are you talking about treaties signed by alien governments, illegal regimes? Why not conduct a plebiscite? As was done in 1961, March 1961, for the people of Southern Cameroon to determine where the people of Bakassi would like to, which nationality they would like to claim. But again, it was said that it was Bangladesh. Everybody was talking rubbish. Are you a lawyer? What do you know that we're talking about? And so, we went there, deceiving ourselves, wasting the resources of the country, with all manners of people. At the end of the day, we pour money down the drain. $300 million was wasted on that exercise. Now we're in trouble.
All right, we have Sebastian Horn, who is also a senior advocate of Nigeria, legal practitioner, joining us via phone this morning to give his thoughts on this matter. Morning, and thank you for joining us. Well, yes, listening in to the discussion on ground, what are you in support of the fact that, well, yes, we're within our right to ask for a review of this judgment?
Well, I admit that Nigeria is still within time to appeal against that ruling or to ask for a review. But I have a problem with respect to the moral content of such an appeal. Remember, the judgment was passed several years ago, and Nigeria has already complied with the terms of the judgment. I appreciate the fact that even when somebody has complied with the terms of the judgment, we can ask for it to be set aside. But against the backdrop of the fact that the judges of the International Court of Justice or the appeal panel are also well knowledgeable in law and in facts, and also giving the background that this is a matter that has to do with high-wire international politics. I do believe strongly that our appeal to that court may not necessarily be successful.
Why?
Because remember, this is a matter that has to do with international politics. Nigeria has complied, and several years thereafter, with only few days remaining to appeal, they now want to jump up and appeal. It is likely that the panel that will seek to review that judgment will look at bad faith on the side of Nigeria and may likely say, no, we're not going to accede. And for God's sake, I think the International Court of Justice relied on the evidence before them. I had written once before on this issue, which was published in the papers, because the initial mistake was made by the government of the day to sign those treaties and then cede Bakassi to Cameroon. In law, in fact, under the 1969 Convention on the Law of Treaties, a treaty includes an act, an agreement, and any other written instrument between two countries within the ambit of international law, agreeing on a certain thing. Now, some arguments have been advanced that if the National Assembly does not or has not ratified that particular treaty, it means it's not applicable or it cannot be enforced. No, I beg to disagree, because we are talking of international law. Yes, in Nigeria, it cannot be enforced by any law court, if that is the true position. But as far as international law is concerned, the law is that no court shall interpret an international obligation. Interpret a local law, for instance, the Convention of Nigeria, as to conflict with an international obligation they have voluntarily entered into. And that has been settled in America and the United Kingdom. Remember, we're operating the same presidential system with the USA, and we're also operating the same federal constitution with the USA. And decisions from those countries are applicable here. I remember that in the year 2000, the Supreme Court of Nigeria also had to pronounce on the validity of an international treaty in the case of Falana against Abacha. And they reached these conclusions I'm telling you now. So I do believe that, yes, Nigeria has the right of appeal in that judgment because we still have few days to remain. But I believe strongly that we will just embark on another round of waste of public funds to go to that, to embark on that course of action. I would rather suggest that there's vast land between Cross River, between Calabar and Ogoja, that the federal government will compulsorily acquire and resettle the Bakassi people. It's a very simple issue. Let us not go to the international, so let's not go and embarrass ourselves in the eyes of the international community again. With due respect. That is my humble submission.
Okay, just hold on before you go. We've got to we'll let Mr. Falana respond to this matter, and then we'll get your thoughts on this matter. You heard his submission.
Well, with profound respect to my very good friend, Mr. Hon, senior advocate of Nigeria, the case of Fawemi and Abacha and Fawemi that he referred to, was actually decided in favor of the Constitution by the Supreme Court. It was a split decision of 4-3, and the majority view was that the African Charter within the territory of Nigeria is an act of the National Assembly. They were interpreting the African Charter Ratification and Enforcement Act of 1993, and that in the hierarchy of superiority of laws in Nigeria, the Constitution will come first before the African Charter. Whether we agree with that or not in international is another matter. What I'm saying is that we mess up this whole case, and the fact that we are still within time to ask for a review, there is no embarrassment in that.
No question of bad faith.
There's no bad faith. If you come into fresh evidence, that is why the rules of procedure of the court provides for a review within 10 years. So there is no embarrassment. There's no, bad faith in that. There. Now, the other point that is very crucial here is that, and I must concede this, until a few weeks ago, I was also of the view that what should concern ourselves with now is the resettlement of the people, more so that 2.5 billion naira was provided for that exercise. And the fact that since 2006, on a monthly basis, the statutory allocation of Bakassi local government in Cross River State,
who's been collecting it?
It's been collected. It's been paid. Up till now, till tomorrow. Well, you should find out. When I'm just telling you, because under the Nigerian Constitution, I'm talking of the first schedule, to the Constitution, Bakassi is number 4.
It hasn't been
on
deleted.
The list. No, it's not deleted yet.
Wow.
The Constitution has been amended. It's not been deleted. It's still part of the territory of Nigeria. And even politically, President Olusegun Obasanjo has been saying, oh, Nigeria is an indissoluble territory. Ceded part of the territory of Nigeria, without following the law. So the point I'm making therefore is that if fresh evidence, as is being alleged, has now come into our possession,
Okay.
including the 1811 treaty, where the British government signed a treaty acquiring that territory. If in 1994, the British government, as is being alleged, maintained that territory belonged to Nigeria, the Bakassi Peninsula.
And that's another vital document which was never tendered.
Of course, we have the right and to worsen the case. And this is why the question of embarrassment does not come in. The British government was one of the witnesses to the Green Tree Agreement in New York.
I see.
So
Okay.
if there was suppression of material facts, if there was fraud, right? If fresh evidence emerges, you can ask for a review of any judgment, either in a municipal or international tribunal.